Hello, everyone. Welcome to Court with Krissy. Last lineup before the courts close for Christmas, and everybody's hoping to get ho-ho home for the holidays. But don't worry, I left a few humbugs in the bunch, all the way to the very end. I hope you like it. Court with Krissy is now in session.
No, she didn't wait. You sound weird.
All right, good morning. May I have your name?
Gabrielle Hankerson.
You said last name Hankerson?
Yes.
All right, so Ms. Hankerson, hang tight for me. You have a couple of cases here. All right, so the first case you have is battery, family violence. I have set the bond at $2,500. And give me one moment, let me switch over to your other case. Before I switch over, let me just tell you on your battery family violence, you do have a no contact. That is to stay away and have no contact with. And I understand you all have a shared residence. I'm not allowing you to go back to that residence that's located at. Now, I did put in my order that you can make an appointment with the sheriff's office within 10 days of bonding out. And once you make that appointment, have them escort you back to the property to collect some of your personal belongings. But other than that, don't return back to that residence. And your other two charges that you have are felony charges. You have a felony criminal damage to property in the second degree. That bond is $2,500. And then you have a possession of a Schedule I controlled substance. I've set that bond at $3,500. So your total bond between both cases is $8,500. So that's what you'll need to pay to bond out for both cases. Now, I've scheduled, hold on, give me 1 second, and then I'll ask you if you have any questions, okay? So I went ahead and scheduled both of your cases on the same court date that's coming up, and that will be on January 22nd at 8:30 in the morning. That's your preliminary hearing to determine if there's enough evidence to continue to keep you detained. That's only if you're still in jail. If you make bond before then, you won't have court on that date. All right, I did receive your application for a court-appointed attorney. I am appointing an attorney to represent you. Okay, what questions do you have, Ms. Hankerson?
No, there we are.
So,
No.
okay, all right, so you're going to have to sign twice. You have two cases, so make sure you sign both of them on the system before you leave, okay?
Yes.
All right, that's all I have. Thank you.
Next lady's welcome.
Famous courts reconvened.
You can be seated. All right. We've got one walk-in this morning that we're going to handle first, and then we'll jump over to our jail cases. First up today is going to be, is it Sariana? Fail to appear again. It's not necessarily certain that you would get a no ARPA next time, all right? So, any other questions today?
Yes, sir.
Then you may go with the bailiff. Thank you. All right. Officer Riley, is that you down there today?
Yes, sir.
How are you doing today?
Oh, not too bad. How about yourself?
Oh, I can't complain. In fact, I wouldn't complain at all given the fact that we've got a pretty manageable docket for a Monday.
Right.
So, any changes?
No, sir.
All right, very well. First up today is going to be Tara Adikari. Good afternoon, sir. Are you Mr. Adikari?
Yes, sir.
All right, and your English is limited, correct?
Yeah.
All right, so we're going to muddle our way through this. So you're on probation. You were placed on probation back in September, and the probation department is claiming that you violated your probation. They're saying that you were ordered not to consume alcohol, and then in fact you did. Understand? So they say you drank, and you weren't allowed to. You understand that?
Yeah.
Okay. Today, I'm going to enter a denial on your behalf, so it's like not guilty. We need to get an interpreter here for your next court appearance, all right?
Yeah.
What is your current address? Are you employed? Do you have a job?
Yeah, we don't have job right now.
Not right now?
Not right now.
And you were arrested way back. Yeah, you've been in jail now for a couple of weeks?
Yes, sir.
Okay. Maybe that's what this is. It is. All right, I've got to review the information that the probation department sent to me, so hang tight, okay?
Okay.
Is there anything you want to say before I set your bond? I'm going to enter a denial. It's like pleading not guilty. I'm going to set your bond at $2,500. I'm going to make it cash, surety, or 10%. So you can post 10% of that with the clerk and be released. But you're not to consume any alcohol or use any drugs. And if you get out before your next court date, you have to report to the probation department as soon as you get out. Do you understand? And I'll order that if you're released, you need to have a monitor placed on your ankle to verify your compliance with the no drinking.
Okay.
Now, we'll send you notice of your next court date through the mail. It looks like in this case, you did have a lawyer. So if you want to get a lawyer for the probation thing, then you'll need to fill out a new application. Understand? And you have PV, you have, they're trying to revoke your probation in 2 of your cases. So you need to fill out that application as soon as possible. Do you understand? Any other questions today, sir?
No question, sir.
All right, then you may go with the officer. Thank you.
Then when you release for me?
You'll have to post a bond of $2,500, either all in cash, through a bail bondsman, or you can post 10% of that with the clerk's office. They'll explain the details to you at the jail. Any other questions?
No, we don't have money, sir, right now. We don't have job. We don't have anything. So how can pay the 2,500?
If you're unable to post the bond, then you'll continue to be held at the jail. We will set this very quickly. Your next hearing in the other case is scheduled for January the 15th. I would imagine we would set your case with us either before then or right around that same date. Any other questions?
No, sir. Thank you.
Then you may go with the officer. Thank you, Mr. Adikari.
Thank you.
Next we have Kaden Davis. Good afternoon, sir. Are you Mr. Davis?
Yes, sir. Yes, sir.
All right. Mr. Davis, you understand your rights in court today?
Yes, sir.
Did you receive a copy of the complaint in your case?
Yes.
Did you read it? Do you understand you've been charged with disorderly conduct persisting?
Yes, Your Honor.
Actually, if you look at it close enough, you're charged with disorderly conduct persisting, but I think they meant persisting. It's a 4th-degree misdemeanor, carries up to 30 days in jail and a $250 fine. You have a right to have me read your complaint out loud in its entirety, but it's not required. Would you like for me to read it or not?
Yes, Your Honor. Sure.
The Officer Fox of the Johnstown Police Department is alleging that on or about December the 20th of this year, within the city of Johnstown in Lincoln County, Ohio, that you recklessly caused inconvenience, annoyance, or alarm to another by engaging in fighting and threatening harm to persons or property, or in violent or turbulent behavior, and persisted after in disorderly conduct after a reasonable warning or request to desist. So, do you understand that that's the charge?
Yes, Your Honor.
How would you like to plead?
Not guilty.
And what is your current address?
I've been with them.
All right, well, let me take a quick look here at the file, then we're going to talk about your bond, so just sit tight for me, all right?
All right. Do I have a word by any chance?
Well, here's what I'll tell you, a little clue. If I give you an opportunity to speak, the chances of you getting an OR bond are slim to none. If I just go ahead and set your bond, it's a pretty good bet you're getting an OR, so just sit tight for me, all right?
Yes, Your Honor.
All right, good news for you. I'm not going to give you an opportunity to speak.
Yes, Your Honor.
Okay, here's what we're going to do today, Mr. Davis. I'm going to go ahead and I'm going to release you on your own recognizance, and the only specific condition that I'll put on that is as long as the bond is in place, meaning as long as this case is active, you're not to return to Henson's Pub. I'm not putting a prohibition on consumption of alcohol. I'm not even going to put on a no contact order because based on my reading the reports, it doesn't look like you're acquainted with the individual who was allegedly involved on the other side of this thing. So what's going to happen next is this. Your case gets randomly assigned to a judge. We'll set it for trial, and we'll send you notice of when that next court date is going to be through the mail. So make sure the address that you put on your bond paperwork down there is where you want your notice to go. If you get a lawyer, all the notices will go through your attorney, so it's critical that you stay in close contact with that person. You have the right to hire your own counsel, but you are eligible to ask the court to provide an attorney for you for free. The application form is available at the jail, but since you're being released, it'll be your responsibility to get that turned in. Regardless of whether, if you want to get a lawyer, regardless of how, you need to deal with that right away. Do not wait until the day of your trial to deal with getting an attorney. Do you understand?
Yes, Your Honor.
All right. Any other questions today, Mr. Davis?
No, Your Honor.
Then you may go with the officer. Thank you.
Have a great day.
You do the same. Francisco Molina. Good
Hello,
afternoon,
Judge.
sir. Are you Mr. Molina?
I am. All right.
And Mr. Molina, do you understand your rights in court today, sir?
I do.
Did you receive a copy of the complaint that was filed against you?
I did.
Did you read it and understand you've been charged with disorderly conduct?
I do. Yes.
As they've charged it, they arrested you on suspicion of something else. Looks like probably an M4. But the prosecutor's office, when they reviewed the matter, believed that it only rose to the level of a minor misdemeanor. So under Ohio law, that carries up to a $150 fine, no jail time. Understand?
Yeah, I do.
How would you like to plead, sir?
I'm going to plead guilty to this.
Okay. Before I accept your plea, I need to ask you a few questions, but I will give you a chance to speak before I make any decisions regarding sentencing, okay?
Sure.
You are not required to plead guilty. Nobody can force you to. You're presumed to be not guilty. The state has the burden of proof beyond a reasonable doubt, and on this charge, you have a right to a trial with a judge, but not a jury. Understand?
Okay. Okay.
If you plead guilty, you admit that you were disorderly. They don't have to prove anything for me to find you guilty. You give up your right to a trial. I'm going to simply impose sentence, and we're going to be done. Understand?
Yeah.
All right. Let me take a quick look at the file, and then, as promised, I'll give you a chance to make a statement if you wish.
Okay. Thank you.
Okay. So this all went down last night? Or no? Early morning hours of
Sunday.
Sunday, but technically an extension of Saturday night. Fair enough. Okay, I kind of have a gist of what went down. What do you want to say, if anything, before I make any decisions here?
Thank you. Honestly, I made a mistake looking at my choices in not calming the situation versus I think being again the drink and just having a long day, a very bad day. I felt the individual was going in to fight, and I didn't want to do that. I went outside and I should have calmed things down, but I also recognized that there was, for some reason, the saying a gun was involved, things like that. So
I saw that too, and it said that there was never a gun involved. So yeah.
No, there wasn't, and that's why I said there wasn't. I didn't even punch the individual. I pushed him. But again, I take that all back. I should have stayed calm. I should have done better, and I didn't. So this helped me learn my lesson being here.
Well, let me ask you a question, Mr. Molina.
Sure.
According to the complaint, you're from Reading, PA, which I know is near Philly. What brings you to Central Ohio?
So what I've been doing was, first off, part of my unemployment, I am unemployed currently, but I was working on my consulting. I'd also done some things for local people on social media, so there were individuals that I met several weeks ago at the hub that I had worked with and kind of learned some things to do that as part of my own rebuild of my brand, my business, versus going back to just IT. So I had met one person, a couple people there, was delivering gifts, was actually wrapping up last night because I had planned on going back home to Reading. Was going to give them some of the things, and I had some toys and stuff that they had a toy drive. Went in for a drink and changed. The people weren't there that I was used to seeing, and I made a bad choice. So that's why I'm here in Ohio. Just was trying to do more of an early Christmas in some cases and do some work for the community. while I had the opportunity before I went back to corporate life.
Yeah. So how long ago did you get into Newark?
So I was in and around the Newark area since I'd say the beginning of December, but I've stayed in Pickerington, Newark, Zanesville, just meeting people.
Yeah, I was just curious. So, all right. Well, you may be old enough to remember, not necessarily that location, but that bar where you were was originally a burger chef. I don't know if you remember that restaurant, but no?
Never been here.
All right. Well, you're not that much younger than me, so you should remember that. But anyway, here's what we're going to do. I'll go ahead and impose a $150 fine, or you pay court costs. You'll be on your way in a couple hours after the process shall. Do you have any questions?
Thank you. No, sir. Thank you very much, and have a wonderful holiday.
You do the same. Have a safe trip back east. Here you go.
Thank you.
Officer Riley, you got anybody else down there I don't know about?
Nope, that's everybody.
Fantastic. Well, we're closed tomorrow, so I will see you on, actually next week, because it's Judge George's week. You have a good Christmas, and I'll see you on the other side.
Yep, thanks, you too.
All right.
Have a Merry Christmas.
Court stands in recess.
I didn't know about fiscal.
All right. I'd like to shut up.
May I have your name, please?
It's public. Ma'am?
May I have your name, please?
Yeah, Gerald Miller.
Good afternoon. Mr. Miller, we're on the record.
Yes.
The case number is 24-3366FY and 24-3404FY. You're appearing for arraignment purposes in each of those cases. You're appearing with Ms. Mistley, the defense attorney available through the Indigent Defense Council here to assist you. Ms. Mistley, did you have opportunity to review allegations on the complaints, nature of the offenses, and possible maximum penalties in each of these cases?
I did, and we will waive a formal reading of the 2 felony complaints and her pleas of not guilty and request the assignment of counsel.
In order to complete a petition for court-appointed attorney, I need to place you under oath and ask you some questions. Mr. Miller, would you please raise your right hand? And you swear that the information you're about to give me will be the truth to the best of your knowledge.
Yes, ma'am.
Thank you, and you're welcome to lower your hand. Mr. Miller, what's your phone number? What is your mailing address?
Renting and living with others. This is my mother-in-law's house. So we pay rent, and there are others there. There's her mother and her mother's husband. And her
Are you
daughters.
employed?
Yes, ma'am.
Where do you work?
I have a couple of different occupations. I'm a full-time employee of Summer Logistics. They're an Amazon distributor. I drive a van for them and deliver Amazon products to customers. Packages. Full-time.
And what is your average take-home pay?
My what?
Average take-home pay.
Like per week? About $800.
And you have another job?
Yes, I work for, I drive for Lyft, and I also drive for DoorDash. Those are driving apps, delivery apps.
And so what's the combination of all of those jobs as far as your average take-home pay?
$1,500 a week. If I can stop getting locked up, I could actually work a complete week. So.
Do you own a vehicle?
Yes, I do. It's in the impound right now, and I'd like to get it out.
What's the estimated value of the vehicle?
$35,000.
Are you making payments or do you own it outright?
I make payments.
Do you have any money in a checking account, savings account, any cash on hand, or any digital currency?
Yes. To all of those.
And how much?
Right now, because I haven't done my taxes yet, I have about, I don't know, 800 in my savings account, roughly 100 in my Lyft account, and my DoorDash account, I don't have anything in it because I drew it all out. My checking account, no, there's nothing in my checking right now. I moved it all to my savings. My direct deposit goes to my savings account.
Okay.
I'm
We'll
also,
appoint an attorney for you.
yep. You're appointing an
Do
attorney?
you have enough money in any of those accounts in the combination of all to afford to hire your own attorney?
I don't know what an attorney costs in Michigan, so I have no idea.
I can represent to the court, Your Honor, that if $900 in cash is all he has, that's not going to be anywhere near enough for retainer fees in the 2 felony files, or even one of them.
So I will appoint an attorney for you. I'm going to remind you that you have the right to remain silent. Anything that you say orally or in writing can be used against you. You have the right to have an attorney present during any questioning. If you could not afford an attorney, the court would appoint one at public expense. You have the right to have the attorney present during all subsequent court proceedings. You have the right to a preliminary examination. In this case, we will schedule both of them, I think.
Are we going to address?
Preliminary examinations will be scheduled for January 13th, 11 a.m. with Judge Stepka. Also on January 6th, you'll have a probable cause conference. So bond was set in the
what were the dates? I missed that.
FY. I'm sorry, sir, we can't talk at the same time.
I didn't hear the dates that you said, Your Honor. I'm just asking a question. And there's a lot of background noise because he's counsel and close the door.
Close the door so we can hear you and you can hear us.
Close the fucking door. Well, you taking orders from that judge, though? I bet. Shut that door. Fucking clown.
Okay, you're in court, and I will expect that you will behave like you know you're in court.
I'm off my meds, ma'am. I don't have my medication. They're not giving me my Lexapro or any of my heart meds. I'm not well right now. I'm sorry. I need help. My apologies to the court.
So you're welcome to remain silent. Ms. DeLee, bond has been set in case number 24-3404 FY. Do you have questions or concerns regarding that bond?
Yes, what was it set at? What was it set at, please?
It's a $25,000, 10% bond.
So we would ask the court to review the bond as set in 3404 and to consider a reduction of that bond. You know, as he told you, he's working full-time plus residing with family. We certainly recognize that he has some prior record here. It appears that much of it is older in the 1990s and in the earlier 2000s. Then there was some misdemeanor, rogue and vagabond, probably what we may call either a trespass or a disorderly in Michigan in 2023. We would ask the court to review and reduce the $25,000 10% bond.
So the allegations in 3404 occurred at a time that Mr. Miller was on bond in the other case. The court's information is that he has no ties to the area. He has known failure to appears. You know, that both of them being 10% bonds, I think they are appropriately set. Regarding the bond violation, how is it that Mr. Miller wishes to proceed?
He will be entering a plea of not guilty and requesting hearing on the alleged bond violation.
The court will get that hearing scheduled as quickly as possible. I am going to continue each bond as they were previously set. If you post the bonds, make sure that the court has a valid address where you will be receiving your mail. You should hear from your court-appointed attorneys by the end of next week in each of these cases. Once again, your preliminary examinations will be on January 13th. Ms. Lee, anything further?
I have nothing further, thank you.
I have a question.
Ms. Miller?
Okay, so post bond, 10% on this 25,000. Then I have a preliminary hearing on the 13th, correct?
Yes, sir.
Am I following? Okay. Does there still stand a possibility of that bond being revoked as a result of some negative ruling on the first bond violation? Can I be rearrested is what I'm asking you after I post this $25,000 bond?
Well, the $25,000 bond is in case number 24-3404. The bond violation allegation is in case number 24-3366. So you understand you have two felonies that you are facing right now. You know that, right?
Yes, I totally understand that.
Okay, well, the bond violation is in the other case. It's not in the newest case.
Right, I get that. I'm not completely clear on Michigan laws. They're a little weird to me. I'm from Maryland. So, like I'm asking.
I don't know what the judge would do at the time of the hearing, and I can't hazard a guess. Until the time of the hearing, you'll be remanded for the bond violation. So you won't be able to post, I mean, you could post the bond, but it wouldn't do you any good until after the hearing anyway.
Okay, well then you just answered my question.
Thank you.
Christ.
You're all set.
We didn't do Huff?
No,
Okay.
we didn't come back to him.
Oh, okay. I knew I had
Yes, Your
crossed
Honor,
it out.
I was able to review those on the.
Yeah, have you had a chance? I just
yeah, I
saw
did.
the other case come through.
Yes, Your Honor, I did. And I want to thank Ms. Falk for being sending it to me. The one of them was blurry, so it took me a few minutes to figure out what was going on, but that's fine.
All right, Mr. Huff, position 1024 CR 008252J, where he's charged at one count of battery family violence. I had here 23 cycles. Let me go over to the other case, which is 24 CR 00825. No, that's the same one, 2J. What's the add-on case number?
No, the case number is 024 CR 0.
Oh, 56. I'm sorry, it's very
56.
close. I
Yeah.
see. 8256J. The first one was 8252J. I'm sorry, so it is different number. And what is the charge? I just pulled it up.
Both of them are battery family violence.
Oh, both are the same. Okay. I'm just looking at the add-on calendar now. Sorry. All right. And I think I still have, you all want to briefly do the history. And I had cases out of Birmingham for assault and pandering. Yeah.
Huh? Pandering. Hold on.
I thought, nope, didn't I have pandering?
He did have a pandering.
Yeah, Marietta.
Okay.
All right, that's 23 open. You want me to go over it? Or you good?
Briefly, I think I'm good.
All right.
Okay. Go ahead, State.
All righty. Now the cases are intertwined, but I'll read the facts separately, and I'll start with the case that's alleged to have happened on October 22nd, 2024. But basically, the victim reported to Atlanta Police Department on the 23rd an incident that took place on the 22nd. The victim advised that the previous day that she had been drinking, and when she met up with the defendant, the defendant had been drinking when they met up. The victim advised that the defendant got upset with her and a verbal dispute began. The victim stated that he had her call a guy and read from a script that he prepared or whatever. She advised that this was his way of trying to get the guy to say something to incriminate her. When nothing incriminating was mentioned, the victim advised that the defendant began to yell at her and began to punching on her. She advised that the defendant kept her phone and would not let her have it back. She stated that he began to verbally repeat, "You gonna leave me." The victim advised that she eventually succumbed and submitted, and that they spent the night together. She advised that it was not until the defendant assaulted his father, which is the other case, that she made a outcry about the assault that had happened the night before. The victim had visible swelling to the left side of her head. The two have been living together in the same household for a month. The victim's name in this case is Angel Brown. I will move on to the next case, Your Honor. The facts of that case are as follows. On October 23rd, which is just the day, I guess, after the original incident, or the first incident, officers responded to on a person injured incident that occurred at, that is the incident location for the first case as well. The victim had been punched with a closed fist and struck in the head by his son, the son being the defendant in this case. They shared the exact same name, which is Djuamiel Huff as the last name, which caused a laceration to his left eye that the officers observed. An officer also observed the eye was bleeding profusely. The victim stated that his son's girlfriend, Angel Brown, the victim in the other case, called and stated that she had been in an altercation with her boyfriend and that she needed help with moving her property out of their shared apartment. The victim rented a U-Haul, the victim being the father, rented a U-Haul truck, and they went to the apartment to start moving when the defendant seemed surprised to see his dad. The defendant asked the dad, "What are you doing here?" At which point he punched the father in the face and started the altercation. The defendant fled the scene while the victim and Miss Brown relocated to the Metropolitan Parkway, where they ultimately met up with the officer. The victim was treated on the scene by Grady EMS. The victim stated that his son was on drugs and needed some help. Miss Brown advised that to the responding officer that she had reported the incident involving the defendant to another officer earlier that morning. Your Honor, again, I want to point to the criminal history, which is it may just read, and I'm being facetious when I say just, but it may just read as 29 cycles, but it is sprawled across at least 3 states. It is to include aggravated assault. It is to include a battery family violence conviction that was ultimately pled down to battery in Clayton County. It is to include an actual battery family violence conviction out of Muskogee County as recent as 2017. The state sought to have this matter upgraded to a felony, and we're still in the process of doing so. However, we accused it today to avoid any sort of Riverside issue. The convictions go on. There is a 2022 battery conviction out of Muskogee. There is a 2021 possession of a firearm by a convicted felon conviction out of Muskogee. Originally, that was charged, or he was arrested for pointing or aiming a gun or pistol at another with that charge. There is a 2021 battery conviction out of Muskogee as well as there is a March 4th, 2024 willful obstruction of a law enforcement officer conviction out of Clayton County, to which he received 12 months of probation that was suspended and 30 days to serve in custody. He would have been on probation at the time of this offense, Your Honor. I think that we heard about the arrest for theft by receiving and the arrest for pandering, and the battery family violence arrest that was ultimately null prost, which is a separate charge, but it was a battery family violence arrest with battery in 4 counts of simple battery out of Clayton County in 2015 that was ultimately null prost. And then as it relates to his other charges in other states, there's a 2011 wave sounding charge. Wave sounding is because it's a major case. That was and another arrest for weapons carried concealed and accessory after the fact. There is another arrest, a 2015 arrest for assault, and a 2015 arrest for assault and robbery. Given all of that, Your Honor, it is quite clear that the defendant is not taking this matter seriously. We are of the position that this is in fact a felony. We're just waiting to hear back from the DA's office at this point. But the recommendation from the state would be a similar recommendation on both cases. It would be $10,000 surety bond on each count of battery family violence, which the state contends is a felony. No alcohol, drugs, or weapons. A stay away from that incident location. No contact with either victim in this case. and the completion of a family violence intervention program. If we could sound for Ms. Brown and Mr. Huff in accordance with Marcy's law, Your Honor, that'd be greatly appreciated. There is nothing further to add from the state at this time.
All right. Ms. Brown, Mr. Huff, I'm sorry, Ms. Brown and Mr. Yeah. Do we have either of them on the line? Nope. All right. You emailing it?
Yeah. I'm so sorry, what'd you say?
The Huff is on the line.
Hold on, I think we do have Mr. Huff. Mr. Huff, do
Yes.
you wish to address the court today, yes or no?
Yes, I do.
Raise your right hand so I can swear you in. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right, put your hand down for me. Are you in fear of your son, Mr. Huff?
No, I'm not.
Do you want to have any further contact with him?
Yes.
Okay, does he live with you?
Yes.
Okay. And how old is your son?
32.
Okay.
Could I say something, Your Honor?
Briefly, but this is not his trial. This is just his bond
Okay.
hearing.
Him and Angel, this case was amplified by the police officer. I never wanted him charged with hitting me. I was him and her were both drunk the day before. I had went over there and I took their keys from them. And what it was something she had found in his phone or something like that started the whole incident. But earlier that day, the police officer concluded that nothing happened with him and her and let her go. The officer who came when I called the ambulance, he's the one filed the report. And I told him I didn't want to press charges. Miss Brown told him she didn't want to press charges either. And Miss Brown lives with my mother right now. So we don't want him charged. This was amplified by the police officer.
Mr. Huff, if I may ask, and I'm a representative of the state, why did you call the ambulance?
I called the ambulance because see, I didn't want him charged because I put my hands on him first. I didn't want them, either one of them driving. So it's not like he hit me for he really was like trying to get out the door. I told the police officer that I didn't want him charged. He went on and did it himself. Amplified this case. This case was amplified, and her and him still go together. If he had a bond, she'd probably be the one to bond him out. So this is a waste of the taxpayers' money. I told the officer, I told the victim's advocate. She told the victim's advocate that she didn't want to charge. The only reason she changed her number because the victim's advocate was threatening her like she could get charged with something when we told that officer initially that we didn't want to charge him with anything. They had too much to drink the night before. That's basically what it was. And I know he has a history, but he was driving a cab. He had just started the job driving a cab when he was arrested. She was in the cab with him. So it's just a waste of time. He has made some changes for as being sober, and he goes to AA. So I think that this case is amplified. I'm not scared of him, and trust me, she's not scared of him either.
And Your Honor, I just notate that our victim witness advocate has not spoken with the victim in this case, and
she spoke with both of us. It was like a month ago. Well, right after it happened, they called me and they called her. And
do you remember the person's name you spoke with?
Her name was Detective Brown or Brown, I think. She called and she was like, "Well, we could still."
Well, hold on, I don't want to hear the conversation. A detective would be with the police department.
Well,
there are no detectives with the solicitor's office.
She said she was a victim's advocate. She called my phone. She left me messages, and I didn't hear nothing else from them until today. We actually thought it was over with. Me, Angel, and him, we thought it was over with. Till he got that job driving a cab. The first day he went out, he got pulled over by a police officer.
Okay.
And I
Yeah.
guess, Your Honor, if I could just point out that one of the major concerns that we have is one of his arrests here in Georgia is for false imprisonment. And the facts that were alleged in the first incident was eerily similar to the concept of false imprisonment, where the victim even said that she almost felt coerced and she stayed there. She submitted in an effort to, I guess to go along, to get along. He took her phone and he tried to prevent her from doing several other things. In addition to that, he wrote a script for her to call someone, which is eerily similar to the level of manipulation that is constant in these domestic violence situations. And so outside of his criminal history, which is a ton of gun, a ton of battery, a ton of violence, we just like for the matter to be taken, into account that this may be a situation of intimidation.
Your Honor, can I say something?
Briefly.
Once again, this is amplified. They were just high on weed and they had been drinking a lot, and I think they had took an ecstasy pill, and she found out he was cheating on her, something in the phone. It was like, I'm not blaming either one of them, but they was just too high. Typical, it happens in the hood. I hate to say it.
No, we don't want to admit that it's typical and happens in the hood.
Yeah, I'm ashamed to admit that, but people do crazy stuff. But he realized the seriousness of it, because I told him they will use your record to amplify it and try to get you more time. Some small can be amplified.
But right now I'm talking about bond. He hasn't been sentenced. He hasn't gone to trial.
I want my charges dropped, and if she need to do something to get hers dropped, she'll get them dropped. I don't think it should go no further than this, because she didn't come because she was scared, because the lady was telling her like she could be charged if she don't press charges.
Well, and she made a false claim or there's perjury, things of that nature. So they may have been, but it sounds like you were talking to a police detective, and they may have advocates there as well. But
yeah, her name.
If they have detective in front of their name, they're not with the solicitor's office.
The only reason
that's not important at the moment.
The only reason I came today, I told him this morning I didn't want to do the court thing or anything like that, because I thought it was over with. But I know that if I didn't come forward with the facts, that it'll be amplified to another level, as if he tried to kill somebody or something.
Well, he's not charged with that. These are misdemeanors. But as a victim, yes, you have a right to be here to explain. But again, this is not the trial. This is not the forum or the time for that. I'm not here to sort out the facts. Okay. Yep. I'm not here for that today.
Yes, ma'am.
I'm here to make sure that with his history, he's going to return to court. He's not going to abscond from the state or be there, and that he's going to comply with the bond conditions.
He just started his job, so he don't have no money. All this will do is make him lose his job. If he stay in jail, the jail will get paid for housing him. But she's not in fear. I'm not in fear. So it's really no need for him to be incarcerated. And it happened in October. We done moved on as a family.
We'd just like to notate, Your Honor, when we did speak to Mr. Huff today, we asked him for contact information for her, and he indicated that he did not have so. So
she doesn't want to be contacted because she's.
But you cannot speak for her, Mr. Huff. She needs to speak for herself. She needs to speak for herself.
But she felt like they was pushing her to push a case that she don't want to push.
Well, but when the police are called and they do their investigation, they're the ones that also have a say in determining about the charges as well.
Another officer earlier that day concluded that incident had no plausibility, right? So then
they would not have brought charges. So let me not argue with you back and forth on that, because we're wasting time. And that's not what I'm here for today.
Your Honor, we don't know if she's the same victim in these underlying convictions.
No, she's not. That's his ex-baby mama.
Okay. Well, but it also indicates
battery, family violence.
Yeah, it indicates a serious problem with females and things of that nature. And these type of charges are all very similar. With different females makes it even worse, because it just says that he has issues. And so those will need to be sorted out at some time in his life. And he needs to get some counseling and help for that, so he can learn to deal positively with women. So I'll say that and I'll move on. Deputy, wow. Deborah Melnick. I've given you another title. PD Melnick. What would you say on behalf of Mr. Huff?
Your Honor, I mean, basically, his
Please
fault.
mute yourself, Mr. Huff.
Okay.
Thank you. Go ahead.
No, Mr. Huff Jr., you are not speaking. Okay, I'm not going to let you speak. No, no. You can beg all you want. No. Anyway, Your Honor, basically, this did happen in October. There have not been any additional incidences. You've heard the father, and so, sorry, you've heard my. You've heard the father, and we would ask for a signature bond, and we have no objection to any type of domestic violence counseling while he's out on bond.
Okay. He's a multi-state offender, which concerns me as well. And the history definitely concerns me. And I will say to Father Mr. Huff that Miss Angel Brown needs to come forward and speak for herself in a environment that would not show that she's been influenced or coerced by you or the defendant, okay? And until she does that, there's nobody else that can speak for her. For all we know, you know, she's being influenced by you all. You're providing housing for her or whatever, and we want to make sure that she's safe. Because even in the hood, people deserve to be safe and not be intimidated or coerced by the situations, okay? And that's what it looks like from the outside looking in. I'll be honest with you. So she needs to speak for herself in an uninfluenced situation, which means she needs to come down to the office by herself, okay? So that we can make sure that she is safe. And so I'm going to order on the first case, which is the one ending in 8252J. And with that one, the first case, the victim is the dad or Angel Brown?
Miss Brown.
Miss Brown. In that case, I'm going to order a $5,000 surety bond. And with that $5,000 surety bond, I'm going to order this address. Order that Mr. Huff, your son, have no further contact with Angel Brown, even though it happened in October. We're just in December, but I want to make sure that she's safe and not being intimidated. So right now, to make sure that there truly is a long cooling off period and that she's not being influenced or intimidated, no further contact right now while he's on bond. He's to stay 200 yards away from her, and which is 2 football fields. And he's not to contact her right now. No drugs, alcohol, weapons, or guns while on bond. And in the second case with you, Mr. Huff, since you still want to have contact with him, you can do that, but it should be no further violent contact. So I don't care what he's on, what he's taking. If he gets violent with you, he can be rearrested. No drugs, alcohol, weapons, or guns. He needs to not drink. I'm glad he's going to AA meetings. I'm going to put that in the order that he should continue to go to his AA meetings. He should not use drugs and he should not drink alcohol. Obviously, it doesn't bode well for him. And, you know, no unprescribed medication, no knives, no guns in both cases while on bond. So he can be around you, but not Miss Brown right now. Okay. And that's until we can sort this out.
Your Honor.
Right?
She was intimidated by the police, like pressuring her to press a case that we told the officer initially that we didn't want to press.
Well, you can't say what she doesn't want to do. You can say what you.
I can
Stop
only
saying
say,
we.
yeah.
I need you to say I, okay? But not we, because when you say we, there throws it back in that you can't speak for her. She needs to say to the officers. Now, if she didn't say to the officers, then they don't know.
Okay.
And they're probably thinking she's intimidated. But you can't keep saying me and she and we don't want to do it. It needs to be I. I don't want to press charges against my son, but she's got to say it for herself. And they have to be convinced that it's true. And if it's not, then they'll do what they have to do as officers. All right. You have a question, Ms. Lewis?
I do, Judge. You didn't say the bond amount on the add-on charge.
5,000 on both, surety. And, let's see, on the second case with the add-on, hold on.
You had no further violent contact with the father and continue on AAE meetings.
Right. Actually, the conditions ought to be the same on both. And I'll tell you this, with the father, I'll make it 400 instead of 500. 500 on the first one with Ms. Brown, 400 surety on the one with the father.
500 on position 10 and 400 on the
add-on.
And the original one.
4,000. Did you say 4,000 or 400?
Judge, you said 400, but you said 5,000 first, so I was confused too.
Yeah, I was.
I meant to say 5,000 and 4,000. I'm sorry.
I was like 500 and
I'm sorry, Your Honor.
400.
Can you repeat that with everyone speaking? I can't. What was the final bond?
The bond on the first case, which is position 10, is a 5,000 surety.
Okay, thank
On
you.
the add-on case that's ending in 256J is 4,000 surety.
$9,000 surety for both
Total
charges?
for both cases, yes.
It's a felony.
Excuse me, what was that clip that was unnecessary?
Anyway, let's move on, everybody. Anything else?
I'll make one more thing clear on the conditions. On
Yes.
10 is no further contact with Angel Brown. That was the only
Right.
condition, and no alcohol, no drugs, no weapons, and to continue on AAA meetings.
Right.
So there's no stay away.
With her, yes, I
But I
said
didn't
that
get
he
the
would have to.
address.
Well, I don't have the address that Mr. Huff can give us the address. He said she was staying with his mother, but I'm going to say that he should stay away from her wherever she lives or works, 200 yards. And if she's at his mother's house, she can give us that address. And we'll get it from her. And so, wherever Miss Brown is, that
I just put stay away for the resident, the living resident, whatever.
and work address of Miss Huff. Yes, that's sufficient enough. So he shouldn't go to her job and he shouldn't go to his grandmother's house to see Miss Brown because he can be arrested. But he can go to his dad's house, which is a different location on Tremont, I believe he said, or Tree something. He can go to his dad's house, I guess, as long as Miss Brown is not there. Miss Brown is there, then he can't go to his dad's either. Because he has to stay away from Miss Brown, 200 yards.
Got it.
All right. We want to make sure Miss Brown is safe. And again, Mr. Huff, you can pass along the message to Miss Brown. Tell her to come down to the solicitor's office and talk to the victim witness advocate, not to the police department per se, because she's talked to them, but I don't think she's talked to the victim witness advocate at the solicitor's office. That's a different person. All right.
Yes, Your Honor. I will speak with him before he does anything. Mr. Huff, please do not come. I'm sorry. I will speak with you, but do not say anything else. Do not give any more addresses and do not give any advice. Thank you.
All right. Thank you. Next case.